agenda items on this one.
Okay. Good evening. This is the November 14th meeting of the Planning and Development Committee. We have a quorum, and we'd like to call the meeting to order. Could we get a motion for the approval of the minutes of October 24th? Are there any questions, any additions? Not all in favor?
Aye.
We have, first item for discussion is P1, Ordinance 97-0-11, granting a special use for a Type 2 restaurant at 724 Clark Street in the D2 Downtown Retail Zone, Core Zoning District. Staff and the Zoning Board of Appeals recommends the adoption of Ordinance 97-0-11, granting a special use permit for the operation of a Type 2 restaurant at 724 Clark Street with suggested conditions on employee parking and store hours. The proposed operator of the site currently operates the Subway at 1133 Evanston Street. Is there a motion?
So move. Second.
It's been moved and second. Are there any questions, comments? First, Alderman Fisk.
Yeah. I just wanted to make sure with staff that this is, the special use is tied to the owner and not to the land. I can't get this open.
Dennis Marino, Manager of Planning and Zoning. Alderman, the special use is tied to the operator and also to the location, the address.
Great, thanks.
Okay. Are there any other questions? Alderman Nguyen.
Yes, I have a question about the owner of this restaurant is also the owner of a Subway at Ridge and Emerson.
Yes.
Are there any plans to close that restaurant, or will this cause any issues with respect to business for that restaurant? Because they're fairly close together.
Alderman, when the owner-operator is
here.
here, if you would approach the microphone, please.
Hi, my name is Suhas Patel, and I have the store at Emerson and Ridge, and this is the second location that we are trying to open, and there is no plan of closing this. We have the belief and some investigation that we did that it will support both stores without having any kind of impact. So we are not closing any stores. It will be
Okay.
2 stores.
All right.
Okay. Any other questions, comments?
Do we know? Do you know what number Subway this will be in Evanston? Is this
This is
the 6 or 7? No.
This is I think 8 or 9.
8 or 9.
store, yeah.
Okay. All right.
It's a significant business out there, and otherwise I would not be investing on my investment if I don't think that it will support my it will impact my other store.
Okay. Do you own any others beside the one at Ridge and Emerson?
No, this is my second location. I don't have anything else.
All right. Thank you.
Great. Alderman Rainey? No? Okay, thank you.
Thank you for your time.
Okay, it's been moved in second. All in favor?
Aye.
Any opposed? All right. And this is for introduction tonight. P2, Ordinance 99-0-11, granting a special use for an automobile body repair shop at 1961 Dempster Street in the C2 Commercial Zoning District. Staff and the Zoning Board of Appeals recommended the adoption of Ordinance 99-0-11, granting a special use permit for the operation of an automobile body repair shop at 1961 Dempster Street. A1 Auto Care currently operates an automobile repair service at 1961 Dempster with 5 bays available for car repair. The applicant proposes to transform one of the bays into one for automobile body repair, which requires a special use permit. Is there a motion?
Move approval.
Second. It's been moved in second. Is there any questions, comments? This would be Alderman Breathwaite. It's the second ward. I know he. Yes, he didn't tell me he didn't, so I'm assuming that's okay.
It is a very different use, but since the bays are already there, they're only going to alter
Alter
one
one,
bay for
absolutely.
the use of this, which sort of makes sense.
It does make sense.
Yeah.
Just to expand the business a little bit.
Right.
Any other questions, comments? Not all in favor?
Aye.
Any opposed? Okay. P3, ordinance 38-0-11, licensed rental units. Staff recommends the adoption of proposed ordinance 38-0-11 regarding licensing for rental dwelling units, amending Title 5, Chapter 8 of the City Code to be effective July 1, 2012. The proposed ordinance was a discussion item at the July 25th, 2011 Planning and Development Committee meeting and was brought back for further discussion at the October 10th, 2011 Planning and Development Committee meeting. Is there a motion?
Yeah, motion to introduce?
Yes.
Second.
It's been moved in second. We have some citizens' comments, so we would like to call the citizens that want to speak first before we go into any discussion.
Madam Chairman, could I ask you a question?
Go ahead.
Was this in our online packet?
Yes, ma'am, it was.
Yes, it was.
We provided it Friday.
But it wasn't in the Thursday link?
No.
that-
No,
was in the-
we-
it was in
it
the
was
revised
subsequent to
packet.
that on Friday. Yes, ma'am.
I missed the.
It was in the revised packet.
Okay, all right, I'll look for it.
All right. We have 4 people. Miss Esther, Betty Sue Esther, Lisa Pillis, Stephen Monticelli, and Jane Evans. If you just line up at the...
Good evening. My name is Betty Esther. I stay at 2031 Church Street. I have spoke against this ordinance before, but it's interesting to see that have some questions. This won't start effective until June the 1st of 2012. In one of the budget presentations and the things that was going to be happening, there wasn't any little line that gave us how much money is this supposed to bring in to the city. I know we say it's a small amount. The small amount is passed on to the tenants. But I would like to know exactly how much have been projected to hit the budget in June. It would be, if it starts in July, it would be in August. So if someone can get us that figure, so when we look at the budget, we know what is the budget amount that we're going to be adding from imposing this new fee on people that own and rent to the individuals that rent apartments here in Evanston. How much are the rental residents going to have to add extra to the budget? Thank you.
Thank you.
Hi, my name is Lisa Pildes. I live across the street at 2111 Ridge Avenue. I'm here wearing 2 hats. I've lived in the Fireman's Park neighborhood for 31 years, and we raised our family here. We're also local landlords, and we own 5 properties in the Fireman's Park neighborhood, which are rented to Northwestern students. As a resident, I know the impact the student population can have on a neighborhood. I wish I had $1 for every time I've been woken up in the middle of the night because of party noise, and another one for every beer can and red cup I've had to pick up off my lawn. Although they are the exceptions, those students have a big impact on the livability of our neighborhood. As a landlord, I've also had the pleasure of meeting hundreds of smart, serious, sincere young people who are the future of our country. They're looking for clean, affordable places to live, and they wish to be treated with respect and consideration by their landlords and by their neighbors. They're embarrassed to be prejudged as rowdy, drunken interlopers to our neighborhood. I don't object to registering or licensing rental property, and I think raising the registration fee in order to help pay for property standards inspections is fine with me. But licensing as a way to enforce the occupancy code is poorly thought out. We Fireman's Park neighbors know that a few bad apples have spoiled the barrel. There are certain properties and landlords who are problems year after year after year. Not only are those properties rented to students who are not respectful of the neighborhood, but the parties they hold attract hundreds of students at a time who treat our neighborhood as if it were New Orleans during Mardi Gras. Landlords who do not vet their applicants and monitor their antisocial behavior have a much greater impact on our neighborhood than whether there are 3 students or 4 living in an apartment. After all, would you rather have 4 quiet students or 3 students who have 100 people over for a kegger in their backyard? The city's goal is to make rental housing safe, affordable, and an asset to the neighborhood. The enforcement of building and property standards codes relating to bedroom and living space square footage, the condition of the apartments, and the existence of nuisance behavior by tenants or their guests is what is important for protecting renters and the quality of life in our neighborhood. There are apartments in our neighborhood which could be cited for these violations without ever reaching the occupancy issue. You propose to revoke a license for 6 months only for over-occupancy. In other words, a landlord who has 3 tenants living with numerous egregious safety violations would not have his license revoked. But a landlord renting an otherwise safe and code-compliant 4-bedroom apartment to 4 people could have his license revoked. That is patently unfair and does not promote the conditions which the city should be trying to encourage, namely safe, affordable housing and livable neighborhoods. What will happen, for example, if a 4-bedroom apartment is rented to 3 people, but more than 3 move in? You are holding landlords responsible when they might not be able to monitor this occupancy behavior. Tenants have privacy rights, after all, and landlords cannot make surprise visits to count beds. If the landlord is cited and the license for the apartment is revoked, all the tenants will have to move out, not just those over the 3-person limit. What will happen to the tenants? After all, there is still a lease in force. Will the landlord have to take the tenants to court to evict them? And where will the tenants go?
Thank you. Stephen.
Good evening, council members. My name is Stephen Monticelli. I'm the Community Relations Vice President for Student Government. I'm here as a student and as a representative of students. I'd like to echo some of the points the previous commenter made. Student government in general does support the spirit of this ordinance. We think that enforcing or putting in place better enforcement mechanisms to make sure that safety and safety code violations are not being looked over is extremely important to students. We think that having safe, affordable living spaces is only to our benefit. However, the recent inclusion of the language that provides an overly broad justification for this ordinance to be used against properties that have occupants over the limit of 3, it is what we think is beyond the proposed intent of this piece of legislation. We support increased safety enforcement. However, the ordinance, if put into effect as written, will have a disproportionate effect against students. The recent list of properties with code violations had a disproportionate amount of housing units inhabited by students. And out of roughly the 35% of students that live off campus, about 40% have over 3 roommates, not including themselves. So that would mean that 40% of students have about 4 or more roommates, including themselves. That is approximately about 1,000 students that could face eviction if an ordinance like this is put into effect. We would like to simply propose that some things be reconsidered in the ordinance. There are other models of this type of licensing ordinance, such as one established in Palatine that does not provide a blanket fee on properties that are not nuisance properties. And we believe that there are other methods of enforcing safety without encroaching on the ability for students to live within a reasonable distance from the school in safe neighborhoods. Like the previous speaker said, there are problem houses. There are bad apples. We recognize that, and we are trying to do things to work towards educating students on the needs of their neighbors and on what it means to be a good neighbor. But this ordinance, if put into effect, we believe would have a very serious negative effect on students. And it goes a bit contrary towards, it's a bit contrary to what we have been told in the past, that students will not be facing eviction if an ordinance like this will be put into place. So that's all. Thank you.
Thank you.
My name is Jane Evans, and I have lived at 813 Gaffield for 24 years. I've been before the council many times in regards to my neighborhood. And I am not tonight planning on addressing anything that has to do with occupancy, because I don't believe that's what we're talking about tonight. I think there will be a time and a place to discuss occupancy, whether it's 3 unrelated or whatever that may be. But I don't think that's what this is about. I think that my neighborhood has become somewhat of a business for a number of people, and that's what I'm addressing tonight. This, for me, is not about the students. This is about the landlords. And so I am here to support the proposed ordinance for the licensing of rental units. What we have now is not working, because clearly I've been under the impression for I think 24 years, correct me if I'm wrong, that the 3 unrelated rule has been in effect since I've lived in my house. And so this is not a new thing. This is something that if we choose, or the city council chooses to address it, it's something that will be addressed yet again. But it's not being addressed in this ordinance as far as I can read. What we have is not working, and there's a lack of ability to enforce what we have. Living in the 5th Ward as I do, there are so many students that have been taken advantage of by unscrupulous landlords that believe that it's okay not to maintain their properties and that it's okay to overlook unsafe living conditions. We as neighbors have had to look at these properties every day, and believe me, it affects the quality of life in my neighborhood for not just the homeowners, but for the students, quite frankly, as well. This ordinance creates a system with teeth for addressing the many problems. It will be an assurance to a renter that the licensed unit meets minimum standards. It will allow the city to finally, and this is really the most important piece, it will allow the city to finally have a current record of who truly owns a property, and most important, how to contact them and whomever they have managing their property locally with a current telephone number, an email address, and an address, which quite frankly we don't have now. I keep hearing landlords complain that they are being penalized. The nominal fee that would take part in this ordinance is part of the cost of doing business in Evanston. And let's not kid ourselves. My neighborhood is a big business. And on a side note, where I work, my business or my company has to renew its business license every year. Licensing is a tool to help enforce the law of non-compliant landlords. It will help pay for additional inspectors. Hopefully that's what part of this money will be used for. Quite frankly, we're counting on that. We used to have an inspector that was designated to the 5th Ward, and that was eliminated years ago due to budget cuts. He is sorely missed. And I bring that up because we sometimes don't have history in what we've had and what we haven't had. And so for a number of years, the 5th Ward did have an inspector, and that was cut out of the budget many years ago. Someone has to pay for these inspections, and someone has to pay for the inspectors. And it only makes sense that the landlords should pay their fair share. And I just want to, the last note, I just want to make it clear, As far as I'm concerned, this ordinance is not about the students. This ordinance is about landlords maintaining their properties. Thank you.
Thank you. We had a separate planning and development sign-up sheet, but some of you signed in on the council sheet. We're going to pull those off now. Mr. Handler, Mrs. Blades, and Mr. Bean, did you want to speak as well? It's sort of crossed out on here. I'm not sure. Did you want to speak? Okay. All right, fine. So Barbara Blades, Howard Handler.
Actually, I'm hoping to speak at both meetings, but I apologize if my thoughts are a little disorganized because, frankly, this was a surprise that this ordinance popped up so fast and is being presented at the City Council this evening. A couple of years ago, a lot of landlords were packed into this room, and kind of when licensing was shot down by the council at that point, one of the aldermen at the time, who no longer sits on this council, said, staff keeps presenting new and new regulations, but aren't doing anything, enforcing the existing regulations. There's always going to be a new regulation needed, according to this alderman, that's going to solve the big problem, whatever the problem is. Your previous speaker said, that was just up here, said, well, there's not, this is an opportunity to now finally collect names and email addresses and contact information of property owners. Well, that's what the rental registration ordinance was for. And now when we contact city staff to say, can we have that list, they say we don't have access. There's no list. No such record occurs, and we can't access that list. So either that existing ordinance didn't work and they haven't followed through on it, or they're purposely withholding information. It's only one of those two options. Additionally, this list of 52 properties that was just sent out there a couple months or a month or two ago, again, I'm going to repeat, this list was completely fabricated. No investigations, no notices to property owners, no determination of if the violations were valid or not. Your assistant city manager told you guys, I just read the minutes before I came here, he said, well, we had complaints that students didn't get their security deposit back. That is not the role for city staff. I don't think they understand what their role is. If they had licensing a month ago, 2 months ago, 52 properties would have had their licenses revoked. Again, no notification, no investigation, and for things that the city doesn't have the authority to do. And I'm going to wrap up, I apologize. But this is not the time to move forward on licensing. This is a time to, again, sit down. Again, the landlord community and the real estate community has asked over and over again, sit down with us. Let's discuss these issues. You have existing ordinances. The city staff is not in a position to be administering a landlord license ordinance, and we ask you to table this and sit down with the real estate community, and let's hash our brains together and let's come up with some policies that work. Thank you.
Just so for your information, Mr. Handler, this is for introduction only, so it's not going to the council tonight. So when you read, you just read a little, maybe too fast. It's only for
It's
introduction.
not on the council agenda?
It's for introduction only.
Right.
Yes, it could be up in 2 weeks.
The first reading is tonight.
Yes.
Thank you.
Ms. Blade?
My subject was covered already, so.
It's been covered already? Okay, all right. Then that is our we have one more speaker. Could you please recite your name and your address?
Yes, my name's Margaret Ronan. I live at 2048 Sherman Avenue. I'm here about the licensing. We're also landlords, smaller properties, just a couple rentals. But I don't have a problem with the licensing, just because I feel better having an inspector come, look at my place, know that the student rental's checked off. I mean, I just always think about Wrigleyville and those balconies, and all we need is a disaster and a fire in Evanston. And, in my neighborhood, there are a lot of students. The student council member himself said 40% of the students are more than 3 unrelated in their housing, and they admit that. And I'm not worried about the 3 unrelated. Personally, I don't care if it goes to 4 or square footage, but I do think that we need some oversight with the licensing. As far as the cost, I agree too. The city doesn't have the staffing right now to do the oversight for the full enforcement of what we have. But I think with the licensing fee, that could help kind of put all of these issues together. The ordinances we have together with the information and an inspector and the money to pay for an inspector to really put it all as a unit so that everything can be, a good oversight on everything. As far as the fee goes, I mean, if I have a three-bedroom place right now, I can get $600 to $800 per student per bedroom. Okay, so a $45, $25 to $45 licensing fee is really not going to break my wallet, okay? As far as the students worrying about that being passed on, if you divide the $25 to $45 between 3 people and 12 months, I think you'll be able to handle it. So basically, I don't think it's going to be a big hardship. As I did hear, this is a business, I mean, we do okay with having the rental properties. But, and it's also, the licensing is a good excuse for me as a landlord to say, hey, I need to come in and check the apartment. The inspector's coming. So it kind of gives me a little backbone to be able to check on how many people are living in the apartment. All I need to do is give 24-hour notice. Yeah, I'm not going to go knocking on the door. That's illegal. But I can give 24-hour notice to my tenant to say, the city inspector's coming. I'd like to come take a look the day before. So I don't have a problem with it. I think the neighborhood really has been hurt by this overdensity. Parking's a big problem. Kids having to store things even in the front yard because I don't know if there's no bike storage. I mean, that's all I have to say. Anyway, thanks for their time.
Thank you. Okay, any comments? Alderman Wilson.
Okay, let's see here.
I have a lot of reservations about this proposed ordinance. First of all, we already have an existing registration requirement. And as some of the speakers alluded to, to me, it's not so much a question of whether or not we have the tools to deal with the problems, but it's a question of the ability and the enforcement of the tools that we already have in place. And there are a number of what I see as probable or very real and realistic problems with the ordinance. For example, there's a three-day mailing notice requirement for the hearing for revoking a license. And that basically says that the city can send out a notice on Tuesday, there'll be a hearing on Friday, and that's not fair because there's a reasonably high probability that the notice is not even going to arrive in time. This requires the city to inspect every single unit. And I just think to myself, well, how long is it going to take the inspectors to look at every single unit in an effective and comprehensive way? How long will it take to go through the Park Evanston? I mean, that's just one building. The inspectors could literally spend days and days on end just going through that one building. And does this include dormitories? Does this include sororities and fraternities? There's a long list, and to me, I don't think that this is even remotely workable to get it addressed within 2 weeks or 3 weeks or 4 weeks. I'm also troubled by the fact that, as near as I can tell, the landlord and business communities haven't been actively engaged in this. Finally, I guess my last and most important point, hopefully, is that this kind of ordinance really should be part of a comprehensive review of the building code ordinance itself. We should be looking at the entire ordinance and putting something cohesive and comprehensive together instead of cobbling this together. This is just, I don't recall which speaker mentioned it, but this is just throwing something out there to try to deal with one particular aspect of a problem, but it's going to have serious, or at least possibly serious, unintended consequences. If a landlord doesn't post the notice, for example, and doesn't get around to it, and it just doesn't do it, that's a fairly minor problem. But the code would permit that person's license to be revoked. And so say it's a 15-unit building or a 20-unit or 30-unit courtyard building. Are we going to revoke the license and evict dozens or hundreds of people? It's irrational. I can't imagine that we would do that, but then that puts us in a position where we are being extremely selective in how we're enforcing, as opposed to having put together something that's comprehensive, works well together, and that our staff can reasonably enforce. There are other concerns I have about the fees. Again, Park Evanston, they're going to pay a huge amount to have all of their units licensed. Is it fair to impose the burden for the inspector fees on the largest buildings, whereas the single units are going to take a disproportionately greater amount of time? The existing ordinance contemplates that. It's a scale, it's a sliding scale, which makes sense. So again, I could go on and on and on, but I don't think anybody wants to go on and on and on. So I think what we should be doing here is tabling this and having the staff put this back into a comprehensive review of the building code ordinance and putting together a package that makes sense for the residents in the city, as well as the landlords.
Alderman Rainey?
Well, I mean, just listening to landlords in the audience who are speaking to us and writing to us, there is conflict. I mean, there are landlords who tonight said, this is a good thing, it will help me be a better landlord. Then there are landlords who say, this is a bad thing, it'll ruin my business. When you say, send this back to staff, I think that's the mistake. I think if we table this, a subcommittee should definitely be created with a couple of landlords, a couple of aldermen. I think we need to work on this so that we can come up with a solution to the problem. I'm not sure if it's licensing. I've always wanted to license landlords. I'm not sure this is exactly how I perceive doing it, but they are a business and they should be licensed. I'm not so sure that we should be able to, result in the eviction of all their tenants. I mean, the scenarios you presented are ridiculous, of course. I mean, we can't have an ordinance that could conceivably do that. On the other hand, I will say to those, and I'm all over the place on this because I just can't focus in on how this is the solution to the problem that I see also. I agree with you on the problems. I'm not so sure about the solution. I was telling Alderman Holmes, about a year and a half ago, maybe 2 years now, constituents of mine and I went to court on a building in the 300 block of Custer. It was not only a property standards horror story, it was a fire department horror story and a police department horror story. It was a 3-flat, still is. In the basement, there were 9 beds with 9 unrelated people living there. The egress and ingress was impossible. If there were a fire, it would have been a disaster. We went to court every single month in Skokie. There were police officers there and city staff and people from our legal department. We went every single month for 12 solid months, with the judge demanding this information and that information and this information. At the end of the 12 months, the case was concluded, and the judge patted the landlord on the back and said, I think you're really trying, and I think you're finally going to get rid of those tenants. And that was the end of the case. I think the city must have spent maybe $50,000 on that case, and just from staff time alone. So I'm not sure that the solutions really result in solving the problem like we're hoping it will, because in that case, it didn't. It didn't help at all. I just think that the landlords and the tenants ought to be involved in formulating a solution here. I think our staff has done its best and keeps presenting us with different proposals over the years, and they're not acceptable to the public or to the council. So let's put something together that can craft a solution that will actually make sense. But I still think it's curious that there are landlords who embrace this and support it. And like Alderman Holmes said before, you know, this isn't even for them. It's for the ones that we can't direct and who will not comply.
Alderman Fisk.
Thank you, Madam Chair. I do think licensing is overdue. I think we license businesses. Licensing provides an opportunity for us to keep in touch, if at the very least, with who owns buildings and the condition. I agree that we have got to figure out a way to have enough staff to be inspecting these buildings to keep the tenants safe. And I'll relay a concern in one of the buildings in my ward at 637 to 41 Library Place. It's a former, long time ago, nurses' dormitory that was transformed into condominiums, all of whom are owned by absentee owners, and it's filled with students. There are balconies on most of the units in this building. The balconies, fortunately, are obviously on the exterior of the building, but were falling down and were caught by staff. Once staff inspected them, suddenly the balconies were shored up with 4x4s. They were in a state of total disrepair, and it was just a terrible accident waiting to happen. I don't know how many kids are living in that building, but it's a significant number of students in that building. And I was very happy at the response from staff, but there was some pushback from the landlords, because each of them owned the individual condos. It was a significant amount of money to repair them. The city persevered, and now they're all repaired. The 4x4s have been removed, and the building is now in a state of repair. No one is going to fall off of a balcony that's collapsed. So I think we really have to be concerned with what it is we're trying to do here, and that is keep people safe. All it would take is for us to have a situation like occurred in Wrigleyville and have a balcony collapse with 40 students on it, and it would be a disaster for us. So I applaud those landlords who recognize, the situation, and also who would be willing to help us find an equitable approach to this. And I do agree that a committee makes good sense, and I would be happy to serve on that. But we really do need to move in this direction. For whatever reason, it's been put off for years and years, and it's obviously time that we need to do something about it. But key to it is having enough staff to enforce.
Okay. Director Griffin?
I know I won't answer all the questions and concerns, but if I could try to address a few. Dormitories, rental and sororities, they're not subject to this ordinance. As far as inspecting, the idea is that we would set up, and we're already programming an application process online for these applications to be ready to go July 1st. And so there won't be the need to go out there and have somebody come in. We can do that online. Where we would inspect, or we would need to inspect if there's been cited code violations in the past. We want to make sure, as a number of the speakers, and I think all the aldermen here are concerned about, whether it's a safe situation, and we will not issue a rental license if there's a pending safety issue. We've had problems being able to get in on a routine basis when we perceive that there's a safety issue, and we're able to do that with this application. We also tried to conceptually do it in a way that the applicant who's applying for the rental license is basically putting the information down, key information about the number of bedrooms, who the emergency contacts are, et cetera, that if any issues come up, then we have an accurate record that's online. So that's what we're attempting to do. We're attempting to do it, not to be punitive and go out, just in 3 days, oh, you made a mistake, we're going to revoke it, but a process that gets us in on a routine basis to make these safety inspections, and that's what this program's all about. And we think we have the staff to do that. We're going to not rely on an application process where somebody's coming in, meeting them out there, but an online application. But yes, we will do inspections for cases that we've had during the year. And revocations, I think all of you know, and a lot of you have queried us in many different respects. It's got to be a pretty darn dangerous place before we're into that business. It's not about just minor issues or grass not being cut or whatever it is. So I know that doesn't address all your issues. We have been looking at it. I'm not sure what more study and review is going to gain. You basically have what you have here tonight. You have a number of landlords that get it. I've gotten a lot of calls from Northwestern parents that say, I'm glad you're doing this, and again, that's kind of what the concept is.
Alderman, when is that your light?
No, it's Alderman Wilson's, but may I speak?
Go ahead.
Thank you. I think that everyone understands what the goal here is to create safe rental housing, and I think that the issues here are some of the finer points in terms of how we get there. I think that Alderman Wilson raises some gaps that appear here, or some serious problems that are presented with the functioning of how this ordinance works when you apply it, that need to be made clear, I think, before I could support it in the way it's drafted right now. I like Alderman Rainey's suggestion of a subcommittee that would work on these issues to make it clear for everyone. I appreciate what staff is saying, that they have the wherewithal to do this right now, and that it would be a very, very egregious case that would be, there would be a revocation. But if you read the ordinance as it's drafted, that's not obvious. So I do think that it has to be refined somewhat, but I think that we're getting closer to our goal here. And I appreciate that Northwestern parents are aware of this, because I think that that's something that has always concerned me, that clearly if a parent is sending a student here, you obviously want them to be in a safe environment. And I appreciate the landlords who have come forward and said that they would like to have something like this, because it's the lousy landlords that cause the problems for everyone. So I completely support the intent, most of this ordinance as it is, but I also see that there are some hitches here in this still. And I also like what Alderman Wilson has said about looking comprehensively at our building ordinance. However, I do think that that will take longer than we may want to take in terms of addressing this specific issue. So I would support forming a subcommittee, but giving it a short date in terms of coming back and reporting back to the committee.
I'm going to call on Alderman Wilson. Did you want to speak again? And Alderman Rainey, but let me just say one thing, and that is that we've talked a lot about students, but this is not just about students. This is about rental property in the city of Evanston, because believe me, there's more properties where people are living than there are, and that they're not students. So I just don't want us to concentrate just on students, because it's not just about students. It's about safe housing in the city of Evanston for everyone. So I just hope that we will all keep that in mind. Alderman Wilson, then Alderman Rainey.
I guess the main thing is I do support having a subcommittee appointed. And can I make a motion on?
Can we let Alderman Rainey
like
speak first before, so that we won't?
Sure.
Okay, go ahead.
And I could go on for 45 minutes about the ordinance, but I'm not going to. Spare everyone.
I'm a little concerned that I don't quite understand the part about the about the code. I think we operate under a code that is more universal than just for Evanston. So maybe the landlord-tenant ordinance needs a little looking at. It's kind of old, and we haven't really addressed the issues under that ordinance for quite a while. But I wanted to ask about the business of ordering the vacation of a unit. And I know this is way far out and a last resort, but I'm just not so sure that the city, and Mr. Farrar can address this, does the city have that power to, without a court determination that a unit has to be vacated?
Madam Chairman, members of the committee, Grant Farrar, Corporation Counsel. With respect to the way the ordinance is currently drafted, in the enforcement section, it speaks to enforcement 5-8-9A with respect to proceedings in the Circuit Court of Cook County. Based upon what I'm hearing with the concerns expressed by the committee tonight, I think it's well taken that the law department do some further research relative to that, and perhaps on the next go-around that we present a legal opinion fully lining and laying all those issues out for the committee's consideration. There's certainly, I think, some good questions that are being raised here that could certainly benefit from additional study and consideration.
And if I could clarify, I think one of Alderman Rainey's questions, when I'm referencing a global approach to the building code, I'm really talking more about enforcement and how we're enforcing things. So I'm not suggesting that we go back and, revisit how many outlets you can put in a kitchen, things like that. I'm just talking about enforcement for all of the different aspects, landlord, tenant, building code violations, and make sure that we're being consistent in our inspection requirements, what we're expecting of our staff. So all of these different components are consistent.
Well, Alderman Holmes.
Alderman Rainey.
The issue with enforcement really isn't inspections. I mean, I think our inspectors do a phenomenal job of inspecting, but their inspections and their citations then have to be enforced, and they're not the enforcer. They're, it's like the police. Our police are out there knocking themselves out, and then you get to court and the judge says bye-bye. So that isn't an issue really for the Property Standards Department, but it's the next step. And I don't know what role we play, and I guess we could go out to Skokie and visit the judges or sit down with the administrative law judges. I don't even know if that's allowed, so.
Okay. Well, if Alderman Wilson wants to make a motion, and I certainly can support a committee as long as we have sort of a date certain, because I don't want it to go on forever. I know to some people this is new. This is not new for me. We've been working on this since 2005 in terms of really trying to address some of the concerns of tenants as well as landlords. And I, know that people have been invited. Whether they participated or not is a whole nother story. We've never had a committee that was suggested by Mr. Handler tonight, but maybe, that could certainly happen with this group that Alderman Rainey has suggested, and I guess that you are going to propose this a motion for that. But I could support it as long as we have a date certain so that we're not just stringing along forever.
Makes sense. So I would move that we form a committee, and I'm open to suggestions on the dates. Logistically, I guess, there's a question of who gets on the committee.
Yeah, I was going to say, let's talk about the composition of the committee.
Right.
And also a date certain.
Right. Perhaps, I'm just bouncing out ideas. Maybe what we do is invite landlords, tenants, interested community members to maybe email or correspond with somebody by, within a week, and from that pool of interested persons, the committee can designate. I'm just bouncing out ideas.
I'd like a little more control over who's on the committee, quite honestly.
I'm saying we could pick from the pool.
Well,
committee would...
I mean, not everybody that we might feel is good for the committee will be, asking to be on it, What if
You could
it's
suggest that they
10
apply.
landlords who have violated every ordinance in the housing code? I mean, I'm just saying I think the mayor needs to appoint the committee with consultation from the council.
Fine with me.
Okay.
That's fine with me.
Director Griffin.
Well, I think Alderman Rainey answered it, but one of the things, since Grant has suggested a look-see, let me get a chance to get out there and the Realtors Association, maybe they want to appoint one of their members, for example.
Sure,
That kind of a
absolutely,
thing.
absolutely.
And bring those kind of ideas back to you as opposed to kind of constructing who would be on it tonight. And I can do that as soon as next meeting or in concert with how Grant answers some of the questions. So certainly by the 28th meeting.
Okay, Alderman Wilson, you want to go ahead with your motion?
I move that we appoint a committee or subcommittee, however the designation would be most appropriate, to review this proposed ordinance and its integration with other aspects of our city code.
And bring it back.
And bring it back, and have the staff bring us a proposal for appointment to the committees at the next meeting,
Okay. Or the 28th.
or the 28th.
You don't want the mayor to appoint? You want the committee to appoint?
Well, I think we're open to how it's going to actually get appointed, but the staff, Mr. Griffin's going to come back to us with a suggestion on the appointments, and we can discuss the methodology at that time.
Would you add to your motion that we would do this and all of this with say, in mind in terms of having this done within the next 3 months? I think that's reasonable.
Yeah.
Yeah, with the
More than reasonable,
with
actually.
the proposed committee to report back by
90 days?
90 days.
90 days.
Is that okay, including Christmas?
Is that okay?
Yeah.
That'll be, end of February?
No longer than that.
Right.
Yeah.
Is that good?
Perfect.
Right. Do we need a
Okay,
vote?
we need a second.
Second.
It's been moved in second. All in favor?
Aye.
Any opposed? Okay. We have that is our last item. There are no communications. Is there a move for adjournment?
So moved.
Motion to adjourn. It's been moved in second. All in favor?
Aye.
Aye. Thank you.